Corner. Time to get served. It's your boy Phil. Let's get rolling into a fresh batch of Tuesday clips for you. First one is coming out of Judge Brian's court, and somebody is getting her so pissed. I love it. Let's roll.
All right, this is case number 224548501. The people of the state of Michigan versus Douglas Holloway. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for an arraignment on a bench warrant. Appearances, please.
For the record, Your Honor, Christina Ritter.
And Your Honor, Austin Gregory, PA 5193 on behalf of Mr. Holloway, who is present via Zoom, has been made order. And Mr. Holloway, please unmute yourself and state your full name for the record.
Holloway, Douglas J. Holloway.
Sir, what do the J stand for?
J-A-Y.
What? Oh, J. J-A-Y. Thank you, Mr. Holloway. Today is the date set for an arraignment on a bench warrant. And it appears that Mr.
Can you hear me?
Yes, sir, we can hear you, but I don't need to hear you at this moment. Can you hear me?
And I apologize. My name is Mr. Brown. I apologize.
Oh, that's Mr. Brown interrupting after I tried to get Mr. Brown to unmute 15 times. All right, can you be quiet?
Yeah, but
Mr. Brown, Mr. Brown, Mr. Brown, Mr. Brown, I am in the middle of a hearing. Sir, please.
And I apologize. I'll wait for you to call me again.
Sir, please just stop talking right now. Please, please, please stop talking. Please stop talking. Thank you. Okay. It appears that Mr. Holloway, capious at a pretrial conference. Mr. Gregory, how are we proceeding?
Your Honor, we do ask that his bond be continued. He did post.
Court is going to set the matter for April the 25th. At 8:34. Mr. Holloway, what are you doing, sir? You're what are you doing?
I'm writing that down. Okay, you say April
25th at 8:34, Mr. Holloway.
Okay, April 24th, right?
5. April 25th at 8:34.
Right. Yes, sir. All right, I'll be there.
I hope so.
Okay, are you finished, Mr. Holloway, so that I can finish?
Yeah. Hopefully. Yeah, I'm finished.
Can you adjust your? I mean, sir, you're being kind of disruptive to the proceedings. You're being disruptive to the proceedings. Can you stabilize your device? Can you stop? Can you
Yes, ma'am.
sit the phone down? Because I'm not sure why the writing is interfering with the device. So, okay, let's put the okay. All right, the court is going to set pretrial conference for April 25th at 8:34. If Mr. Holloway fails to appear, his bond is going to be $5,000 cash surety plus a GPS tether. Anything further with respect to this matter?
No, thank you.
But nothing further, Your Honor.
All right, then we are all set until April the 25th at 8:34. Have a great day, sir, and stay safe.
Now remember, there was a Mr. Brown. That's Mr. Holloway. Mr. Brown's still lurking.
Thank you.
You're welcome. All right, now I'm ready on Mr. Brown.
Yes, ma'am. Can you hear me?
Oh, Mr. Brown, please. Mr. Brown, listen. You are in court, Mr. Brown. Now, the fact that you are on this telephone and that I am allowing you to participate by phone today only because of the anticipated outcome, I need you to understand that you are in court. Please do not speak until we ask you to do so. This is a court proceeding. You are not on a telephone conversation. This is a court proceeding. This is case number 22-444-5301. The people of the state of Michigan versus Abbott Milton Brown. The defendant is charged with 1 count of assault aggravated and 1 count of assault or assault and battery. Today is the date set for a
Mr. Brown.
pretrial conference. The defendant has appeared via non-video telephone, and the only reason I'm allowing him to appear is because the court anticipates that this would be an adjournment. Appearances, please.
For the record, Your Honor, Christina Ritter on behalf of the people.
And Your Honor, Austin Gregory, PA 5193, on behalf of Mr. Brown. Mr. Brown, please state your full name for the record.
Abbott Milton Brown.
Thank you, sir. Today is the date set for a pretrial conference. The defendant's physical appearance and video appearance is waived for today only, Mr. Gregory, how are you proceeding?
Your Honor, this is the date and time for the pretrial conference, and we do not notice the complaining witness present. We do move forward dismissal at this time.
Ms. Ritter?
Judge, I don't see the complaining witness present for today's pretrial conference, Judge. It is the first scheduling of the pretrial conference. I'm going to ask the court to adjourn the pretrial conference to give the complaining witness one more opportunity to appear.
Today is the day set for pretrial conference. The court is going to deny defense counsel's motion for dismissal, grant the people's request for a one-time adjournment, giving them the opportunity to notify the complaining witness of the obligation that they appear before the court. I'm going to adjourn the pre-trial conference to April the 25th at 8:36. And Mr. Brown has to figure out how to use his Zoom or appear in person. He must appear in person. I will not handle his case on the telephone because I have no way of seeing if this is Mr. Brown, or if I want to confirm that it's Mr. Brown, I have no way of confirming that this is Mr. Brown. We have no video evidence of the person who appeared claiming to be Mr. Brown. All right.
Ma'am,
No,
can
sir.
I just?
No, Mr.
No,
Brown.
sir. No,
Mr. Brown, you
sir.
don't need to talk.
No, sir.
No. No.
No, sir. No, sir. No, sir, Mr. Brown. All right. So Mr. Brown is going to appear April 25th in person or on video. Anything further with respect to this matter?
No, thank you, Judge.
Mr. Brown, did you get the court date of April 25th at 8:36 a.m.?
Yes, sir. That is my birthday, and I will be there. I don't know how to work this phone. You punish
Okay,
me for not knowing how to work this phone.
Thank you, Mr. Brown. Then we'll see you in 36th District Court.
I
in person.
apologize, Mr. Brown. You said I'm punishing you? I
Yes,
apologize.
ma'am, because I don't, ma'am, I've been
Mr.
on the
Brown,
phone since 8:15.
Mr. Brown, why are you yelling at me? Let me ask that question. Let me ask that. Why are you yelling at me right now? Why
I
are you
apologize.
yelling at me? Because you have been on the phone since 8:30. Well, the other people who are still in the waiting room, they have been here since 8:32. Additionally,
Well, man,
the
I'm just
other,
doing the
sir,
best I can.
stop talking over me, Mr. Brown. Mr. Brown, stop talking over me. The other 25 people who were on the docket today, they've been here since this morning too. The lawyers and we've been here since this morning too. The difference is we are all participating the way that we should be participating. I am not punishing you, Mr. Brown. I am enforcing the court rules. And the court rule is this, Mr. Brown. You have to appear via video or just like the other people who appeared in person at the court because they did not know how to use the video or they could not have video access. Those people who appeared the way that we were having court before COVID, that's how you have to appear, Mr. Brown. I'm not punishing you. What I'm doing is not giving any special accommodation for you, Mr. Brown. I'm treating you the way I'm treating everyone else. That is, if you cannot appear on video, then you have to appear in person, the way that we used to appear in court before COVID. Is there anything else appropriate for this record, Mr. Gregory?
Nothing further, Your Honor.
Madam Prosecutor,
Nothing further, Judge. Thank you.
then we are all set until April the 25th at 8:36. Have a great day and stay safe.
God bless you, man.
She cut him off.
What else are we ready on?
Bravo, Judge Bryant. Bravo. Here we go. All right. This is a civil battle that gets very heated. This is Judge Appel.
The date on the judgment was
So it's Attorney Mahmoud and versus Attorney Williams, and Judge Appel is playing referee. This is her first appearance on time served, and boy, does she make a statement.
Motion to set aside. So the judgment was entered. This is a 2017 case.
Your Honor, the date on the judgment was March 17th, 2017.
Okay, was it a judgment by default? I see a proof of service.
Let me go back.
It was a default judgment was entered. I have a proof of service showing personal service. That Mr. Lewis was served at his place of employment back on February 9th.
Judge, we understand all that. We're objecting the amount this morning. We're objecting. Mr. Lewis no longer owes any additional funding as it relates to this, Your Honor. He has
So
paid.
you asked for an accounting, Ms. Williams?
Yes, I did. And Mr. Movement cannot give us one because they don't have a contract to which he say he owed the original amount. So
Okay.
Attorney Mahmoud needs to give us the original log for us to show, because he's finished paying this. He's overpaying them. And he can't
Well-
show us.
Okay,
Your Honor, we were here in January and they asked for the same thing, and accounting was sent. And again, I'm more than happy to present one again and mail one out. However, that does not speak to whether or not the garnishment was valid or the writ was valid when it was issued. They're
Yes,
not
the
valid.
judge-
They're not
the amount-
valid.
do not, Ms. Williams, do not interrupt. He didn't
Sorry,
interrupt
Judge.
you.
Sorry, Judge.
They're not valid objections to the garnishment. And the basis of the actual objection is attacking the underlying judgment, which again is inappropriate under the court rules, and the objection should be denied. Just like in January, when the motion to set aside the installment order was granted, this objection should be denied. And once again, I have no issue sending the defendant or the attorney an accounting of what we have so far. And I do believe if I can share my screen, I can show her the balance that I read off to her 2 or 3 different times while we were in the breakout room as well.
You can share your screen.
And I don't need to see his screen because that's not the log that he's required to provide us. He is required to provide us the initial log for the actual judgments to which he's stating is still owed. He's given only the law firm's accounting and not the original accounting for the outstanding bill. That is paid off as of, I don't know how long ago. He's steady billing this.
Do you have proof of that, Ms. Williams?
I know he needs the one to proof of it. He's asking for funding, Your Honor. He has a duty to show it. And he also has the duty to show whether or not he has a signed POA from the initial creditor to be able to keep enforcing his judgment. Not one time, and I asked Mr. Mahmoud for that, not one time has he produced it. He doesn't have standing to bring this action.
Your Honor, once again,
Have you-
she's arguing the underlying judgment.
Once
Which again
again,
is prohibited
You
under
told me
the.
not but you told me not to.
Stop!
It's the third time
Stop!
you cut me off.
Stop! You guys have been on Zoom long enough to know how this goes. Have you filed a written motion, Ms. Williams? No.
I filed my objection to the garnishment, Your Honor.
All right,
The
I'll
debt is
set it
paid
for
in
hearing.
full. Thank you,
I-
Judge.
I'll set it for live hearing. Hold on, I'm giving you the date.
Yes, ma'am.
Nikki, I need a date for a live hearing.
Okay, Judge. How soon?
Well, I need, whenever,
Okay,
with 30 days. Because I'm gonna have a scheduling order, I need documents. Live hearing,
April 18th at 10:30.
April 18th at 10:30. It's live. Plaintiff to provide, parties to file and exchange all documents and receipts they rely upon on or before April 14th.
Yes, ma'am.
Yelling doesn't help, Miss Williams. It doesn't make your point. It just aggravates me.
Your Honor, I'm not hollering, but when you instruct me not to interrupt him, and he continues to interrupt me, I get a little frustrated. So I apologize to the court.
You started that way, Miss Williams. It's not going to change the facts. I'm going to listen to both sides.
Yes, ma'am.
It just makes my process a lot more difficult if you're interrupting each other and yelling.
I
That's
agree
all
with
I'm
the
saying.
interrupting each other, Your Honor.
And the yelling. Thank you. See you back here.
She wouldn't give in. She wouldn't just say it was her. She was interrupting each other. And she's right. She's just trying to go through a process, do what she needs to do, hear both sides. No need to yell. It's great for us, but not for the court. All right. So do we all remember the bench thrower? I had a part 1, which he threw the bench. Part 2, where he apologized about the bench. And now he's part 3, where he gets his sentence and he's still apologizing. He's a nice guy. He was just going through a lot of stuff. I really feel for him. He had a lot going on, and Judge Mom has a little spot in her heart for him, considering what he did and how she reacts to defendants. She has a soft spot for him. And we are going to hear all about his sentence right now.
On behalf of Mr. Terrell.
All right, thank you. And Mr. Terrell, if you can please unmute and state your name for the record. Mr. Chenier, please tap join for the breakout room.
Morning, everyone, say your name.
Gregory Joseph Gerald's, ma'am, my name.
All right, very good, thank you. All right, today's the date scheduled for sentencing and a bond violation. And I will note for the record that I was informed that Mr. Gerald was apparently released on a tether awaiting sentencing. And then much to the contrary of the court's order, And apparently it was an administrative release. And then Mr. Gerald's lo and behold was picked up for having consumed alcohol.
Yeah, you're not wrong, ma'am, not one bit about what you just said at all. May I please explain what, like, I have schizophrenia, and what happened is I was hearing voices like periodically, constantly, over and over and over and over and over again, trying to get me to drink, you know what I mean, like teasing and taunting me. So I started drinking, ma'am, and then that's what happened to me. I'm being honest to God on that situation, what happened, ma'am.
Well, I'm sure you are, sir, and
I
I'm sure you
did
are.
sit there and try, you know, and then like it was like somebody was sitting there like telling me it was okay to drink certain things. So, you know, like I apologize, but you know, I'm telling you the God's honest truth, you know, like, but I do apologize.
I know that, but I'm also making a record because there's a reason why this court indicates no administrative release. This will be one of those, and.
I know. That's why they got me on Suboxone here, ma'am. Like, and it's been helping me a lot more better than actually worrying about taking or drinking any alcohol or anything.
Now, I've heard about this, that they use Suboxone for other reasons than opioid use. They've been using it in alcoholics also, and he goes on to explain that because she's wondering why he's on the Suboxone. But I've heard about the Suboxone for other than opioid use.
Like that, ma'am. I'm just being honest.
The Suboxone is helping you with your alcohol?
Yeah, because all right, I have like a mood disorder, ma'am. Like it's hard to, like, I'm co-occurring codependency. It's hard to explain. Like, it's a dual diagnosis. You know what I mean? Like the like, so like I always like had like some kind of like a split personality that always does something that turns around and makes me feel something kind of different type of way. And then when I'm calm and spaced out and chill, I actually get the kind of help that I need. You know what I mean? So I apologize. You know, it's just.
No, I understand. I understand what you mean, sir.
I've been trying to explain it to my lawyer too as well, like, you know, on how much, like, when I mess up, it's because I have cravings, you know what I mean? Because of dual diagnosis is like always like trying to figure something out. But then when you figure out something that actually stabilizes you with your dual diagnosis, say you got co-occurring disorder or co-occurring dependency, when you have something that levels out your mind, it causes you to think it actually, like, you know what I mean, like the right way, instead of thinking all crisscross, wishy-washy, you know what I mean? When you find something that actually levels out your mood. I apologize, though.
Oh, okay,
I'm just telling you, you know, how much, like, I've been trying to learn from my situations, what's been going on recently.
okay, so there are two cases, one of which is public intoxication, and a subsequent case of malicious destruction of property for, the malicious destruction of property came from while you were in custody. I believe you threw down the podium because you did not like this court's bond that it set.
Yes, ma'am, I apologize for that. I really apologize for that still. I shouldn't have done that, you know what I mean? I should have actually tried to talk the situation out a little bit more, but like, you see on how much, like, I've been arrested, you know what I mean? When I get arrested so many different times, I get frustrated, I get angry a little bit, and then what happened is I took it out on my own self by getting angry at all of you, which I shouldn't have. And I feel like a total jackass, excuse my language, for what I did, you know.
Okay, and I can appreciate and understand that, sir. And counsel, as to the sentencing, we're going to handle the sentencing first.
Thank you, Your Honor. Your Honor, with respect to the sentencing.
I have no idea what you're saying. You're just mumbling.
Background noise. With respect to the sentencing, Your Honor, I've met with Mr. Jarrell on 2 occasions. I met with him in the Wayne County Jail on Saturday to discuss these issues as well as the bond violation. We've gone through the pre-sentence investigation, and there are no additions. Well, I guess there are some additions. He indicated he was not on medication when he spoke with Michelle. He's now, as indicated, since he's been in the Wayne County Jail, on Blackton, as well as two others.
Hold on. Mr. Gerald, I'm going to mute your screen right there for a moment because there's a lot of background noise.
Yes,
If
ma'am.
there's something you'd like to say, just make sure, just raise your hand and so, and we'll
Okay.
unmute you, okay? Oh, okay, hold on. All right, hit unmute, Mr. Gerald.
Poor guy. This poor dude. I feel for him. He's got a lot going on, man. He's trying his hardest.
Yes, Mr. Gerald?
What I'm thinking, ma'am, is honestly, like, when I've been inside of jail, I've been learning from my mistakes, my situations. So the jail time to me doesn't sound like a bad idea if you're wanting to give me jail time for my sentencing. You know what I mean? I'm being honest. It's helped me. I've been taking my medication while I've been in. You know what I mean? I've been doing good. I haven't sat here and messed up, and it's just I don't want to go somewhere and then get into an altercation and then keep on getting sent back and forth, popping in and out, popping in and out, popping in and out.
So,
You know what I
Mr.
mean?
Gerald, let me ask you this question.
Yes, ma'am.
Are you interested in obtaining, treatment?
I was, but I think it would be a better idea if I actually, you know what? I am still, I'm interested in obtaining treatment. But the thing about it is like, I'm just a little bit freaked out because like sometimes I get into an altercation and then I end up back in jail, you know what I mean? And like, or I end up doing something stupid and then we end up to this situation where I'm actually,
So here's my concern. Here's my concern. My
that's what
concern
I'm
is
just
that,
trying to realize, that's all.
okay, my concern is that you were in court or you were in jail for a bond. And you didn't post your bond, but yet Wayne County administratively released you on a personal bond despite this court's $5,000, 10% bond on both of these matters. And you don't have a home to go to, yet they still released you on a bond.
Right. I had a place I was staying at that like my stepfather, like they have, I know like they let me stay there at the point in time, you know, I was very appreciative of that, you know, and then, you know, I'm just trying to think, what do you think would be a good idea? And in a case like this, a guy like me in my shoes, and then I really am sitting here and trying to understand and taking the knowledge from you, you know what I mean? Like trying to let you know, like trying to understand like what to do with my life, like trying to understand how to actually get it together without actually going through the same exact situation over and over and over and over again, and then making everybody else look bad and my own self look bad, you know what I mean?
No, I understand. So, counsel, I think that, I mean, I really don't, the court doesn't have much of a choice, but to send Mr. Jaros to jail.
We discussed that.
So.
Thank you for understanding me, like, because I do understand, like, if I'm in jail, I learn from my mistakes. I do understand that, but not like fully all the way. I just don't want to, I know you said it was something like a 93-day misdemeanor. I know I almost got a month credit. You know what I mean? On both charges, you know what I mean?
Woody Harrelson. I've been dying. I got it. Woody Harrelson. There it is. He's killing me. Sorry for the interruption, but he is reminding me of Woody Harrelson. Finally. Oh, got it.
So,
Right. What the court is mindful of is that despite the fact that Mr. Gerald clearly needs treatment, Mr. Gerald also understands his own limitations and doesn't want to be in a location that is going to
make
cause
me
you to get into a fight with somebody.
pray to end up back and forth all over again.
Yes.
You get what I mean?
Okay. I do.
When I
So
can,
here's what the
when I
court's-
feel like it'd be easy
here's-
to take care of the problem all at once, just, staying in jail,
Okay, so that's what we're going to do. The court's going to indicate 93 days jail.
okay?
The court's going to indicate. Just do a quick count to make sure that I have the number of days accurate.
I apologize. I'm been trying to understand it, like it's a good, like I feel like it's still a good idea because it'll keep me to where I'm calm, cultivated. I'm inside of jail, like things are still getting okay. I'll be all right, and then I'll be able to sit down and think for a while, still.
All right. No, I hear what you're saying, sir. So the court's going to indicate 93 days jail on each count to be served concurrent, credit for 27, so that means 66 days to be served.
All together?
Well, yes, on your sentence.
She used the calculator. 66 days.
I still have to address the bond violation.
Okay,
So,
thank you,
what I'm
ma'am,
also,
by the way.
what I'm also, you're welcome. What I'm also going to indicate is that there is no administrative release, no early release. And so
Okay,
hopefully there's not an administrative release. And that you're serving this time in the Wayne County Jail.
okay.
The court's going to also indicate
April 12th at 9:30.
that as to the bond violation, counsel, is your client pleading guilty or not guilty?
Yes, Your Honor, he is pleading guilty.
Okay, so Mr. Gerald, please raise your right hand.
Yes, ma'am.
Solemnly swear from the testimony you're about to give this matter be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
All right, thank you. Okay, and as to the bond violation that you consumed alcohol in violation of your bond condition, how do you plead?
Down.
Guilty.
And you've gone over your rights with your attorney, correct?
Yes, ma'am.
And you understand those rights?
Yes. No, well, right now my mental state and my mind not all the way fully, but I have been over the rights with my attorney, and I have tried to understand the best of my ability as much as I could.
Okay, so you understand that you have the right to have a hearing in this matter, and that you're choosing to not have a hearing and enter a plea of guilty, correct?
Yes, ma'am.
Okay, you can put your hand down, sir, thank you. And has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, I'm aware of, about how much some of my friends, their backs hurt, what I mean, being around, I apologize. I really don't, I'm telling the truth, I don't doubt that their backs hurt from actually being around, having to go through everything, following me around, making sure I'm all right all the time on a daily basis, all kinds of stuff.
Okay, so what the court's going to do is the court's going to accept your plea of guilty to the bond violation on both cases, 23296 and 23265. And counsel, the court's going to indicate 10 days jail on each count, for each sentence.
Yeah, I can hear it.
So I think that for language, I'm going to say 10 days jail to be served after completion. 66 days.
66, so there would be 10 more days,
So a total of 76, yes,
76 days altogether.
yes.
I've been through this before, ma'am. I don't think it's a bad idea to actually be in here for that long period of that span of time. I've been through this before where I'm it's kind of like helping at the same time because I still talk and conversate with some of the inmates while I'm in here too as well.
Okay. All right, the court's going to suspend the fines and costs.
Thank you very much, Your Honor. Your Honor, also, can you place in your order that he continue to receive his medication?
Yes, Mr. Shemke.
Okay.
Okay.
So for all that, the winding, the twisting, the turns, the podium, the throw-in, and schizophrenia, it was pretty cut and dry. He had nowhere to go. He was crazy in his head. He was drinking. He says, the best thing for me is to just stay in jail, let me learn from my mistakes. And Judge Mom provided it. That was it. It was cut and dry. That was a great update. That was actually update number 3. I have 1 and 2 in my previous videos. All right, so let's go to Judge Fink's courtroom today. She had 2. One was a serious one. I'm going to play that first. An attempted murder bond hearing. And then the second one, the guy's just a clown. But the first one's very serious, has a serious tone to it, and the size of the bond amount is ridiculous. Let's roll.
It indicates flight risk is some history in the past of failing to appear for court, but you are in compliance with your registry obligations. Haven't always been, but you are now. And I don't see any other reason. You have a job, you're supporting your family. I don't see any other reason to think that you might be a flight risk. So I think what we're really talking about here is danger to the community. The things that indicate a possible and ongoing danger to the community are the allegations in this case that you shot somebody 3 times. One of those times being when the alleged victim was already down on the ground from the first 2 shots. And I think that the second thing that indicates danger to the community is the illegal carrying of a firearm. Illegal for anybody to carry a firearm the way that you were, as a concealed weapon without the proper permits. And then also specifically illegal for you to carry a firearm because of your previous convictions. So I think we're looking at those 2 things indicating danger to the community. I don't know what you and Miss Cook were talking about. I know who she is. So I'm somewhat familiar with her situation. I don't know what the 2 of you were talking about or what that conflict began as. I am particularly concerned with 3 shots. The laws of the state of Michigan allow me to hold a person who's charged with murder without a bond, but a person in your situation who allegedly shot someone 3 times, but the person didn't die, there's no such obligation or no such permission to hold a person without murder, which in my opinion is a defect in the statute. So if you were charged with murder, I would hold you without bond. The only reason that I can't do that is because you're not charged with murder, because she's still alive. So I am going to set the bond at $1 million.
Yeah, may I speak? Can you say something? Just,
sure.
Yeah. I know of Val previously living in Ipsy McCobb area. Never had any bad terms with her. That day.
Mr. McCormick, I would ask you to refrain from speaking about anything that happened that day at this time, please.
I do have one question, Ms. Tanha. You said that there was a video showing him getting out of the car. So the part of the statement you made earlier where he is shown firing more than once at her once he got out of the car, that's what the video shows.
That's my understanding, Your Honor. I haven't viewed it myself, but that's my understanding.
Okay, thank you. I'm going to set the bond at $1 million, cash or surety, no 10%. While you're on bond, you're not to have any contact with Veloise Cook. You are not to have any contact with Jameel Smith. You are not to purchase or possess firearms, weapons, or ammunition. Do not leave the state of Michigan without permission of the court. No criminal behavior, no assaultive behavior, no alcohol, marijuana, or illegal drugs. I'm not going to make any do we know where Miss Cook is living right now? Last time I saw her, she was living in Flint, but it sounds like maybe that's not the case.
Well, let me double check.
How long do we know how long she's going to be in the hospital?
I don't know that information, Your Honor.
Your Honor, I would just like to say that I believe $1 million is equivalent to no bond in this case.
I agree.
In his.
I guess since we're back on YouTube and people on YouTube complain about that, I will say something more for the record regarding that. No bond means that under no circumstances can any property or money or surety or guarantee be paid to get the person out of custody. There is no way for the person to bond out.
I can't believe Fink just gave us a shout out by saying we're going to complain about the bond. I think it's appropriate, Fink. You can't give them no bond because it wasn't murder, but $1 million. Fork it up, you can go.
Bond of $1 million may, as a practical matter, be the equivalent of no bond, but it is not the same thing, because property, money, bail bondsman, family member, GoFundMe, whatever, money can be, if there is money or property to post the bond, then it can be posted. That's the difference.
To answer your question, per the police report, Ms. Cook has an address in Ypsilanti Township.
Okay.
That's as specific as I'll get unless the court wants the full.
Okay, well, I'm just thinking about I don't think Mr. McCormick can post this bond. I'm trying to think about what I want to do about a tether. If he can post the bond, it's a significant bond, and it's enough to, in the opinion of the court, to protect the community. And in that case, I want him to be able to continue to work and support his family. So I was trying to figure out if there was something else I could do with the tether. I'm just going to do nothing with the tether. He'll be back in court next week. And if he's able to post the bond, or if the bond gets reduced at that time, then that can be readdressed. So I'm not going to order a tether. Court date is probable cause conference on March 16th at approximately 9 a.m. over Zoom. Mr. McCormick, I know you're unhappy and you disagree, and I'm sorry that we're even having this conversation. So I hope that this gets resolved quickly for you. You're all set.
Thank you.
You're all set, Mr. McCormick.
You can stand up and walk to the door. Thank you.
All right, so then right after him, this clown walks in. So he's all ranting and raving about his rights being violated and blah, 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 blah.
I did not apprehend your verdict, or maybe the last part you just said.
Sure. Judge Simpson ordered you to go to community corrections and told you that if you did not report on March 2nd, then you would be held with you. A bench warrant was going to issue requiring you to be held without bond. So your lawyer told me that you tried to report and you didn't have the money, and that you were given a chance to come back the next day, which you didn't do. So I'm not going to change Judge Simpson's bonds. The reason that he said that is because you've been ordered to go to community corrections multiple times, and you don't go. So now you're being held without bond, no chance to post a bond, and he'll see you on March 16th.
And like I said, I did not violate any bond. I went there twice without having any money. I was experiencing financial hardship. So I was even advised to go cans to pick up, bottles, and I say that's not even sanitary. I'm not gonna do it, but I'm gonna try to come up with money. But
So he didn't want to clean up bottles and cans during community relations. Basically, that's what he's doing. It's a community service. And he didn't want to do it because he didn't want to pick up the cans. So he's going to come up with money, but he didn't come up with the money because he has financial hardship.
for some reason, I do not know why Miss Cheryl or Mrs. Cheryl did not actually let you know that I was there.
Yeah, that's not in your file. You're right. No one told
I
us.
was there. It's not that I was there after court. So
Okay.
after being at court with Judge Simpson, I did the same exact thing he recommended me to do. I went there, but I did not have the $12 at all.
Yeah, I understand what you're telling me.
I
And
went there twice. I went there on Thursday. I called also, and I was advised to come up here Monday, and she was supposed to let you know, guys. And now I'm gonna be here. I have responsibilities. Who's gonna pay for my time? How I'm gonna be able to survive myself, even to provide? I'm wasting time. I have family to take care of. I am responsible. I did what they asked me to do. I did. You guys can contact the community service and ask them if I did not report on that specific day that I was ordered to get there. I went there. I did not violate. I went there. I don't believe that I violate. I don't believe so.
all right.
I
So
did not violate. I reported.
I understand.
Yes,
I
I
hear
did
what you're
not
saying.
violate.
I understand.
I did not.
Okay.
I am very honest talking to you, Your Honor. I did not violate any bond condition as it is stated in your file. I did not.
Okay. Your lawyers can contact Community Corrections and verify what you're saying and file a motion with Judge Simpson.
Sounds fair.
But I'm not going to change the bond set by Judge Simpson.
And even my public defender would have done so prior even to come to court. We have plenty of time. We had a couple hours prior to appear in front of you. And
Mr. Koala,
he has not called the community service to verify what I have told him. He only going to take at least 5 minutes to verify that.
All right, but I still wouldn't change your bond, even if he could tell me.
I did not violate. I am wrongly arrested right now. I cannot be held in here. I have my rights. I have human rights. You cannot arrest me. I already
Mr. Koala, I have made a note.
violating my rights. I'm not gonna let you violate my rights.
Okay.
I did not violate any bond condition.
Mr. Koala, I've put a note to have your
rights.
signed attorney file a motion to have your
I
bond
feel like
accepted
at
as
this
soon as possible.
specific moment, you are not respecting my rights. You violating my right. I am being wrongly held here. I did not violate any bond condition. I did not.
All right, what?
Not reporting.
Okay. I am following the directions that Judge Simpson has given me. That's what I'm doing. I've also talked to
What about the direction that the Constitution stands for, not to violate human rights?
I'm not gonna go
You
through.
cannot arrest
everything.
me.
We're finished with him. Thank you.
Thank you. Shay.
Okay, well, there you have it. Another good show. Today, I'm going to display a little artwork from a member from day one. This is a beautiful portrait of Judge Grandma. And if you know, she's driving up. I did say Buick. Somebody gave her a Cadillac. And that is the actual 36th District Courtroom. And she is looking lovely. We love Judge Grandma, and my favorite part about this artwork is the yarn text. Grim, thanks a lot, buddy. If you have anything you want to send me, artwork, clips, comments, anything, just join the Discord. The Discord link and all the other links, my merch, buy me a coffee, super chats, all that stuff is posted on my channel page. There's the direct link up on the banner. And also, finally, if you want to help the channel grow, it's been growing exponentially. It's been going great, and it's all because of you. Just remember to like all the videos, subscribe to the channel, and also become a member, because I'm dropping a member-only live tomorrow, this Wednesday, where I'm going to be displaying all back clips that I've had in the vault, some fresh clips from today and tomorrow, and also some off the beaten path police pursuits, body cams, and maybe a little even retro law commercials. So see you later, nerds. It's been real. This is your boy Phil. And again, this is Time Served.